It's the Todd Ortloff Show on News Radio KONP. Now, here's Todd.
And welcome to the show. Washington Supreme Court is considering changes to how bail and pretrial release decisions are made in criminal cases. Under a proposal, judges would be more limited in what they can set bail for, only in cases where there's a high likelihood a defendant will intentionally avoid prosecution. Now, at the same time, the system would allow defendants to secure release by paying about 10% of their bail directly to the court. That means not going through a bail bond company anymore. Supporters say the changes are aimed at making the system fairer and less dependent on a person's ability to pay, but critics, including victims advocates, are warning this can lead to more missed court appearances and will raise the concerns about public safety. And public comment on the proposal is open through the end of this month. So joining us now is Tiffany Attrill, founder of the Victim Justice Coalition, a victims advocate with more than 25 years of experience. She's going to talk with us about some concerns surrounding the proposed changes to bail and pre-trial release rules here in Washington. So when you saw this proposal, what was your reaction?
My first reaction was, I cannot believe this is happening. Mm-hmm. That's truly what my reaction was. Slowly over time, I think, as a crime victim advocate, we have seen our Washington State Supreme Court sort of slowly chip away at accountability for defendants charged with crime, and this is just another proposal by defense attorneys to do that.
So why does this matter? Many of us, fortunately, are not in the system as a victim, but this has a lot larger ramification.
Yes. So first of all, this is the type of changes that should be put before the legislature, mm-hmm. before the people, as opposed to just having sweeping changes of this significance put forth by one party, which is the defense attorneys, without sort of proper feedback from all stakeholders, including victims. And so just the manner in which this came forward is troubling. And I think that the general public isn't really aware kind of how, bail bonds and all the process about that is a little bit kind of confusing, or it's not something that's typically well known. And so how this has been proposed by criminal defense attorneys is that it makes it seem like, poor people are the only people that are in jail and arrested, or BIPOC populations. And it's so much more than that. There's more nuances, if that makes sense.
Right.
Yeah.
So your biggest concern with the changes, as it's written right now, this has been a debate that's been going on for about bail and what that should look like. Aside from that, is there anything in this proposal that you could accept?
I had not thought of that question. I'm going to say no.
Well, it's a sweeping change, certainly. I mean, we've not gone into this realm before.
Right, and so public comment. Mm-hmm. The Supreme Court is taking public comment until April 30th, and I think that that's really important for your listeners and for the general public to know what's going on and to weigh in if there are any thoughts, feelings about these proposed changes. And so I think that, having public awareness is very important.
And people should go online and look at this proposal. It's posted. But again, not a lot of public outreach going on this thing. I mean, this is coming up quickly on the public comment, but many of us have not even heard about this or at least realized how far along this idea is.
Right. And folks can go on the Supreme Court website and you can read all of the public comments that have been submitted so far. And you see, I've read them all, and you can see a stark contrast between criminal public defense attorneys, obviously weighing in support, and then other folks, prosecuting attorneys. There are some judges, there are, victims, there are advocates, and there are community members who are weighing in opposition of these reported court rule changes. So getting the word out and having the public be aware is really critical right now.
Okay, so let's talk about kind of the real-world impact. Take us through what happens. We're going to assume this gets in place. What happens when a defendant does not show up, and kind of what that means for a victim, the people that you advocate for?
Right. I have worked with many, many crime victims, survivors, and their families when a defendant failed to appear for court. It's called FTA, failed to appear. And the real-life impact for them is significant. Knowing that the person who committed the crime against them, harmed them, assaulted them, is out there, like in the wind, is terrifying. They're concerned for their safety. There's concerns for witness intimidation, that this individual could, recontact them, threaten them, coerce them to not participate in the criminal justice system. We see that happen often in domestic violence cases, where, domestic violence dynamics, it's not uncommon for offenders to recontact the victims and intimidate them, coerce them, threaten them to not participate in the criminal justice process, which is, leaves the public, it's not safe.
And this really has some significance in domestic violence cases, I would think.
Absolutely.
Do you think that this could make it, because it's already tough enough to get DV victims to testify? How many times we hear about a case where, a charge is brought, but then they can't really pursue it anymore because, well, I'm not going to go against my significant other.
Yeah. The risks of recantation or of a victim not wanting to participate are high when there's a defendant, and the dynamics of domestic violence relationships and are very complex and nuanced, and it's not simple. It's kind of crazy making.
Right. Okay. So the argument from the other side, from the public defenders, is that people can't afford bail. and that's why they need to change this thing, and that there's some due process issues with that as well. And as you mentioned, you've read the comments. What's your reaction to that?
Well, I read a comment, I think it was this morning, that said something to the effect of only poor people are in jail.
Yeah.
And my first thought was, well, it's not a crime to be poor, so someone who's in jail isn't there because they are poor. They are in jail because there is evidence, probable cause, that they committed a crime. So if we break it down, they're not in jail because they're poor. They're in jail because there's evidence that they committed a crime, right?
Right. So let's talk about how this shifts, too, because as you alluded to at the top of our interview here, this goes away. A big change in this would be pretty much doing away with bail bond companies, which is, like it or not, that is one way to track people, right? If they've used a bond, they're
right.
being tracked, or at least under some sort of surveillance, quote unquote, because that bond could come due if they skip town on it or something.
Right.
Talk to that a bit about, because I think that would make it really easy to just give $1,000 to the court and I could just leave.
Yes. So in my work as a victim advocate, I never really thought about or talked to bail bond companies. Like that wasn't part of my work. I didn't really care how that whole part happens. So they've never really been on my radar. But they actually serve a significant purpose in that they track down if a defendant fails to appear, they find them.
Right.
And with these proposed changes, it would basically do away with the bail bond industry, and that responsibility would then fall on our local law enforcement to find people who skip court, issue warrants, arrest them, bring them back to court. Like we in Washington State already have one of the lowest law enforcement officers per capita in the country. And asking our law enforcement to take on this additional task, I don't have any words. It's just not feasible.
Is there a concern as well, too? You're going to flood the courts with these filings, so to speak. I don't know if they have the staff at the court level to realistically enforce people not showing up. I mean, you're going to go from dozens to thousands of court cases that they're financially trying to track, at least.
Right. Well, and I'm not sure what the impact would be on the court, but the impact for victims is delay. Yeah. So if a defendant doesn't show for court, it just prolongs the criminal justice process, which is already incredibly lengthy. It takes much longer for a case to go through the system than it should.
So, as you mentioned, this probably should go through the legislature. I think most people might agree. It's a pretty significant change in how we're doing things here. Feels like an end around.
Yeah.
So how
it absolutely needs to be before the legislature.
So then
not just the Supreme Court.
So then, do you bring this back as some sort of a counter that might be brought through the legislature, and does that even stand a chance?
I don't know.
Yeah.
I don't know. I don't know what's going on in Olympia. There's a lot going on in Olympia.
It's a lot. You're with all of us. We're not sure in a lot of ways what's going on in Olympia sometimes, but yeah, it just seems like this should be brought up through the legislature. I tend to agree with you on this as well. Is there a form of reform in bail reform that you could get your arms wrapped around as a victim's advocate?
I think that just having some process where there is more conversation with all stakeholders at the table, right? So not just having these proposed reforms come forward from criminal defense attorneys, but including all the others who would be impacted by these changes. And that includes crime victims, survivors, and their families.
So as you step back and you look at this, what's really at stake here from the 30,000-foot level for all of us in Washington?
That's a great question. I think fundamentally what this does is it removes judicial discretion. So judges basically have less control when they have concerns about public safety, about victims and defendants moving forward, defendants not showing for court, and the impact of that has, and also for law enforcement.
All right, so April 30th, the last day to get end of this month to get comments in. Go to the state Supreme Court website, correct? And you can file your comments there. You can read everything as well, right?
Correct. You can read everything. And I think the timing of this is interesting in that April 19th to the 25th is Crime Victims' Rights Awareness Week. And so I'm hoping that folks will be able to think about these changes from the lens of a victim, survivor, or family, and think about the impacts for them as well as public safety.
That's Tiffany Attrill, founder of Victims Justice Coalition. You can find out more from them at victimjusticecoalition.org. She's a victim's advocate, some 25 years of experience in that, talking about their concerns surrounding this proposal before the Washington Supreme Court, changing how bail and pretrial release decisions are made in criminal cases in the state of Washington.
This is the Todd Ortloff Show on News Radio KONP.